5 seconds to go. Start. The first relief claimed by the plaintiffs in the suit is a decree for declaration that the reconstituted partnership deed dated 17 February 1992 was illegal and void, and there was no intention or desire of Shri Rajendra Prasad Singh to retire from the partnership, and further that the plaintiffs, being heirs of Shri Rajendra Prasad Singh, will be deemed to be continuing as partners to the extent of his share. It is true that the plaintiffs have also sought rendition of accounts and their share of profits from the partnership as well as interest over the unsecured loan and the principal amount of unsecured loan on rendition of accounts. For getting this relief, the plaintiffs undoubtedly rely upon the partnership deed dated 13th January 1989. However, this deed of 1989 could be relied upon and form the basis of the claim of the plaintiffs only if the partnership deed dated 17th February 1992 was declared as void. If the dated 17th February 1992 was not declared as void and remained valid and operative, the plaintiffs could not fall back upon the earlier partnership deed dated 13th January 1989 to claim rendition of accounts and their share of profits. Therefore, in order to get their share of profits from the partnership business, it was absolutely essential for the plaintiff appellants to have partnership deed dated 17th February 1992 declared as illegal, void, and inoperative. The relief for such a declaration could only be granted by the civil court and not by an arbitrator, as they or Shri Rajendra Prasad Singh, through whom the plaintiffs derive the title, are not party to the said deed. The trial court had therefore rightly held that the matter could not be referred to arbitration, and the view to the contrary taken by the High Court is clearly illegal. Subsection 2 of Section 8 of the 1996 Act says that the application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. As already stated in the earlier part of the judgment, defendant number 3 had moved an application on 25th November 2004 under Section 34 of the Arbitration Act 1940 for staying the proceedings of the title suit and for referring the matter to arbitration. He filed a supplementary petition to the aforesaid application on 16 December 2004. Herein also reference was made to Section 34 of Arbitration Act 1940. Thereafter, he filed an application on 28 February 2005, praying that as the Arbitration Act 1940 had been repealed and the suit is of 1998, to avoid any confusion, his earlier petitions may be treated to have been filed under Section 8 of the Arbitration Act 1996. None of these petitions were accompanied by the original arbitration agreement dated 17th February 1992 or a duly certified copy thereof. In fact, there is no requirement of filing the original arbitration agreement or a duly certified copy thereof under Section 34 of Arbitration Act 1940, and as such there was no occasion for defendant number 3 to file the aforesaid document. Stop.